Okay, the Committee on Parole is called to order. The time is 8:29. Members of the panel today are Mr. Alvin Roche, Mr. Pearl Wise. My name is Tony Marabell. I'll be acting as chair. Our first case is going to be an administrative hearing. It's Moses Jolivet, DOC number 94357, date of birth, September the 4th of 1963. He's a first felony offender. He has a parole eligibility date of September the 4th of 2008. He got entitled to good time. He's serving a life sentence on the charge of an aggravated rape. His counsel is here, Ms. McDonald, I believe. Would you introduce yourself, please, and tell us what you'd like us to know?
Yes, good morning. Thank you for giving me the opportunity to speak with you all. My name is Sophia McDonald, and I am an attorney at the Equal Justice Initiative, speaking on behalf of Mr. Moses Jolivet today. We have represented Mr. Jolivet for over a decade, including at his last parole hearing in February 2020, where he received 2 votes to grant. Mr. Jolivet was 17 at the time of his crime, and at age 59, he is a completely different person. He has always accepted full responsibility for the crime and pled guilty to aggravated rape when he was 17. But since then, he has matured into a deeply remorseful man who has dedicated his adult life to atoning for his past and rehabilitating himself. As I mentioned in the letter that I submitted, Mr. Jolivet has now been incarcerated for 42 years and has really been one of the most exceptional examples of someone who has maintained an excellent prison record over the years. We are just blown away by his record in our experience representing juvenile non-homicide offenders, not only in Louisiana, but nationwide. He really stands out. Mr. Jolivet has been a Class B trustee for over 20 years, and his last write-up was over 20 years ago for failing to make his bed. He has obtained his GED, completed all 4 phases of risk management. He's completed victim awareness 3 times, has earned certificates in dozens of other courses, including substance abuse treatment and other self-help classes. And he has also completed the intensive Thinking for a Change program. We think he is precisely the type of person that the United States Supreme Court had in mind when it required that juvenile non-homicide offenders be given an opportunity to obtain release based on their maturity and their rehabilitation. In fact, his institutional record is so strong that after Graham came down, the Lafayette District Court actually resentenced him to the equivalent of time served in 2011. However, pursuant to a subsequent ruling by the Louisiana Supreme Court in State v. Schaefer, he was resentenced to life with immediate parole eligibility. If granted parole, or if granted a hearing, Mr. Jolivet will be going before the board for a 3rd time. After his parole hearing in 2013, Mr. Jolivet determined it was necessary for him to re-enter society away from Lafayette Parish in order to respect the wishes and the healing of the victim. And so his home plan is with the Louisiana Parole Project in Baton Rouge, directed by Mr. Andrew Hundley. And the Parole Project would provide Mr. Jolivet with wraparound reentry services and would also help coordinate medical care because he has end-stage liver disease, which is complicated by other conditions. And he would also, of course, have the continued support of the Equal Justice Initiative. So for those reasons, we would respectfully request that Mr. Jolivet be scheduled a parole hearing and granted the opportunity to discuss his continued commitment to rehabilitation with the board. Thank you.
Very good presentation. Now ready to vote?
Yes,
Mr. Roche?
Mr. McDonald, based upon the years of incarceration and the medical issues that they offended, my vote is to grant a year.
Ms. Wise?
My vote is the same for the same reason.
Ms. McDonald, my vote likewise is the same, 42 years in prison with the medical issues and the record he has there, likewise to grant his hearing. His hearing.
Thank you so much, board.
Welcome.
Thank you. Take care. Bye-bye.
Well, this was a first for us. I think in the 160 plus hearings we've done, we've never seen, not once, where the inmate does not show up. I don't know exactly why, because we've seen inmates show up even really on their deathbeds. So maybe it's his right, or maybe only because this was a request for a hearing that this was the case. I tried looking up Schaefer, a state for Schaefer, but there's seems to be dozens and dozens of Supreme Court rulings under that name. I'm just gonna go, yeah, this is, I know that, this is like getting, this is more like an academic approach, because this is just pleading for the right for a hearing. So I don't really have so much to say on this. I think it's more like a learning experience than anything else, but of course, love to hear your thoughts as always. And if there are any attorneys or paralegals or anyone who's law gurus that are familiar with this, please do put your comments in there.